Hi, everyone. On behalf of ChangeLab Solutions and the Northeastern Law School Center for Health Policy and Law, I want to thank you all for joining us for Shaping Public Health in the Courts, the Role of Amicus Briefs and Cross-Sector Partnerships. I'm Sabrina Adler, VP of Law at ChangeLab, and I will be moderating today's discussion. Here's what we're going to cover. I'm going to kick us off with just some quick background and level setting, and then we are going to talk about litigation and public health, the role of amicus briefs, and collaboration between attorneys and public health experts. We will then have some time for discussion and questions, so if you have questions as the speakers are presenting, please use the Q&A function in Zoom to submit them, and we will try to get to as many as we can, either through written responses or by addressing them during the live Q&A. Today, I'm really thrilled to be joined by three wonderful speakers. Susan Poland, who is the Associate Executive Director for Public Affairs and Advocacy at the American Public Health Association. Wendy Parmet, who is a law professor at Northeastern University and the co-director of the Center for Health Policy and Law. And Greg Gonsalves, who's a professor of epidemiology of microbial diseases at Yale School of Public Health and also with Defend Public Health. For those who aren't familiar with ChangeLab, we are a nonpartisan nonprofit organization that uses the tools of law and policy to advance health equity. We have an interdisciplinary team, and we partner with communities around the country to improve health and opportunity through policy change. So we encourage you to check out our website for more information. We have many free resources available, and you can Google us or go to changelabsolutions.org or use the QR code on this slide. And today we're really thrilled to be partnering with the Center for Health Policy and Law at Northeastern. The center promotes innovative solutions to public health challenges at home and around the globe, and they work to advance law and policy reforms to strengthen population health, reduce health disparities, and enhance access to affordable, high-quality healthcare. The center also houses the George Consortium, which is a network of over 100 academics, scholars, experts, and practitioners in public health law. And the goal of the consortium is to increase the visibility and understanding of current public health law issues, identify ways to engage, and provide relevant legal analysis and commentary. And then finally, Public Health Law Watch is also an initiative of the George Consortium. It's tasked with monitoring and analyzing litigation activity that affects public health authority. And a lot of the work that they do in that space is housed in these three groups at Northeastern. So more information can be found at that QR code, and Wendy is going to talk a little bit more about their work as well. And then before we dive in, just a quick disclaimer that while several of us are lawyers, and all of us will be talking about legal topics today, none of us is your lawyer. We are not providing legal advice, nor can we. And for that, you will need to consult with an attorney in your jurisdiction. So with that out of the way, let's dive into just some basic background information that I hope will set up the rest of the conversation. I know there are probably folks on the webinar with really varying levels of knowledge and experience when it comes to litigation. For some of you, this might be quite basic, and for others, this will be entirely new. So to start with, what is litigation? Litigation is the process of resolving a dispute using the court system. And while lawsuits might only affect the specific individuals involved and deal with the issues raised during the cases can and often do set legal precedent such that they can have a significant impact on law more generally. And with that, we talk about strategic litigation, which is a type of litigation that seeks to have a larger and longer term impact on society rather than just dealing with the individuals involved in the specific litigation. So it is definitely a form of advocacy and can be one part of an advocacy strategy. It can also be affirmative or defensive, meaning you can use the filing of a lawsuit to achieve certain goals, or you might be in a position of defending against a lawsuit that's been filed by someone else. Litigation can be used for a lot of purposes, including those that you can see on this slide. So holding government, private entities, and others accountable, compelling government to meet its obligations, defending civil society and policies. It can also be used to clarify interpretations of laws, protect and expand rights. So you can think of some very well-known litigation like Brown versus Board of Education, which overturned decades of precedent to declare racial segregation of public schools unconstitutional. It can also impact government powers or authorities in ways that very explicitly or implicitly affect health and equity, which is why we're here today. There are a lot of considerations when determining whether using strategic litigation is an appropriate tool when it comes to policy change. This is definitely not a comprehensive list, but just some of the advantages and disadvantages of litigation as a tool. So, not going to read all of these, but I already mentioned some of the ways in which it can be used in terms of holding folks accountable. Another thing that it can do is provide monetary compensation to harmed parties. It can also be used to lead to legislative or regulatory change. So I'll talk a little bit more about that, but it's not mutually exclusive to legislative or regulatory change. On the flip side, litigation can be very expensive. It can be time intensive. Not always. Both of those things are true, but sometimes it affects one dispute. Sometimes it is broader, as we said. And similarly, it can create legislative or regulatory change, but potentially in a negative way sometimes. And there are elements that are uncertain or unpredictable. It can result in bad or harmful legal precedent. But all of these things are not reasons to not use litigation. These are reasons to be thoughtful about which advocacy tools to use in any given circumstance. So taking into account those various advantages and disadvantages, there are some situations where litigation just really makes sense as a tool. So for example, if there's a lack of clarity around interpretations of or positions on existing law, sometimes the law doesn't need to be completely changed in order to advance equity or protect health. And sometimes there might not be political will to make changes to the law, but strategic litigation can be used to clarify under what circumstances existing protections apply, what certain legal language means. And multiple decisions over the course of years or decades can also add up to very significant legal change. It can be used to defend challenged policies that advance health and equity. So, like I said, it's not always about affirmatively bringing litigation. Sometimes it's about preparing and planning for and then engaging in a strong defense of laws and policies that might be challenged by others. Oftentimes when we're talking about legal authority and things like preemption, so if a unit of government or a non-governmental organization can't pursue the most appropriate or effective policy to advance health equity because they lack the legal authority to, or they've been preempted or prohibited by a legislature from doing that work, then strategic litigation can sometimes be a vehicle for change. Another place where we see litigation being useful is in upholding the structure of government and separation of powers. We are seeing that a lot right now. That's a bedrock principle of our democracy here in the US, those checks and balances. And when there is infringement on that, particularly as we are seeing in terms of the federal executive branch right now, then litigation is often a way to push back against that. And then finally, when existing rights are being infringed or there's a failure to use existing legal authority in ways that harm health, then sometimes you need to compel folks to protect those rights or use that existing authority. And there might be times when litigation isn't the most appropriate tool. So sometimes a totally new law is needed. It's not about a lack of clarity or a law or right being violated. And sometimes that might be pursued through the legislature. And like I said, those tools can be used side by side. They're not mutually exclusive. If you know you have the votes to make a change in a certain legislative body and the legislature has the authority to make that change, then that might be the right avenue. Laws themselves don't always need to be changed also in order to achieve outcomes that improve health. Sometimes the executive branch at the state or state or federal level exercises authority over interpreting and implementing laws or has the ability to promulgate regulations or set enforcement priorities. And that advocacy through that avenue might be effective. And then sometimes it's important, always, I should say, it's important to weigh decisions about litigation, a decision against you. So a negative decision in the court, particularly at a higher level, like at the Supreme Court, either the federal or state Supreme Courts, can foreclose legal options or undo some legal protections, especially when there are things like different courts that come out differently in their interpretations of the law. And sometimes there's backlash from successful litigation. So maybe you'll win in court, but that spurs folks to pass a new law in the legislature. At the same time, it's really important not to avoid litigation out of unreasonable or speculative fears. It's just really about weighing pros and cons, as it is with any form of advocacy. And then finally, just some other considerations or terms or things to think about. So who to engage in decision-making about litigation. I think there are so many stakeholders, including the communities that would be impacted, lawyers, government officials, subject matter experts, funders. And I really want to uplift the community piece. When communities are left out of discussions about litigation, which often happen among lawyers or parties to the litigation, that I think is sort of the more traditional route that has happened in the past, that litigation is seen as something that happens sort of somewhere else in the courts, and it's not really accessible. But it doesn't have to be that way. I would say it shouldn't be that way. And there are definitely ways to engage, starting with educating folks about litigation as a tool, which is what we are trying to do today. And I think we can come back to this point throughout this discussion and also during the Q&A. Then also thinking about whether you have a viable legal argument and exactly what that legal argument is going to be. That is called the cause of action. Determining who you are going to sue and who is going to do the suing, who's filing a lawsuit and who's the defendant. The plaintiff is the term we use for the entity that is filing the lawsuit or making the claim. And it's important that any plaintiffs understand exactly what they're signing up for. And then on the flip side, who is going to be the defendant, the one that's going to be sued, and who can be held accountable, who has the authority to resolve the issue at hand. And then, of course, you need attorneys to work with to litigate the case. So we think about public interest attorneys, government attorneys, the private bar, et cetera. The plaintiffs have to have what we call standing. That's just certain legal requirements to be able to file a lawsuit. So not anyone can file a lawsuit on any topic. There needs to be a connection to the harm in some way. Then you have to pick which court you're going to be in. Different courts have different rules and different precedent, different judges. That's true both across levels of government. So there are state courts and federal courts, and also across different jurisdictions. And sometimes you have a lot of options in terms of which court you're going to file in, and sometimes it's limited. It just really depends on the specifics of the lawsuit. Then there's the question of timing, when to file. There's lots of strategy questions related to that. Is there legislative action pending, as we've discussed? Are there other lawsuits that might affect what law applies here? Is it a coordinated effort? There are sometimes statutes of limitations, which just means there are certain time limits related to certain types of claims, and you have to stick to those time limits. And then finally, what relief are you asking for? So there are different things that you can ask the court to do. There are things like injunctions, damages, et cetera. So in other words, are you asking the court to make sure that the entity that you're suing stops or starts doing something? Are you asking for financial compensation or for some other penalty or action? And the options available really depend on the specific lawsuit. So that's a quick high-level overview of some of the elements of litigation as a strategy. We can get into more details about some of this as we go and answer questions as well. I know that's a lot of information in a very short amount of time, but I want to pass it over to Susan now to talk about APHA's work and connecting litigation to public health.
Thanks, Sabrina, and thank you for including me here in the webinar today. So APHA has a history of engaging with the legal system through Friends of the Court briefs or through actual lawsuits. But in this last 18 months, we have been much more proactive than normal times have required or allowed. We had a conversation very quickly after the election to just see what we were comfortable with, and recognizing that we are a membership organization. We have standing within the community. We have members all over the country, and it is really important that we were standing up for the things that we know were right, which is science and evidence and policies that focused on improving the health of the public. And so what we follow this advocacy approach, which is when we're looking at what is going on, it's important to make them follow the law. And then it's a whole array of people. It's looking at Congress, looking at the administration, working with states, all of these things to assure that the law is being followed. One of the other important issues that we've realized very early on is that Transparency has different meanings to different people, but truly being able to understand why decisions are being made, where is the science and evidence to support it, became an important consideration for us. Part of our role as APHA is also to engage with the public and our members broadly and to let them know what's happening, what the implications are. And this final issue in our advocacy approach is really important and is something that we have stood by, which is just because somebody says something doesn't mean that it needs to be done. And so we were very clear that APHA is a science and evidence-based organization, and we were not going to sit back and make changes to what we said, how we educate the public, how we worked with our members. We were not going to be obedient in anticipation of a potential risk. And that has actually led to a couple of different issues. We are firm believers that when you think about the term DEI, when you lay it out, diversity, equity, and inclusion, these are things that are critical to a healthy, just society and are important for us to continue to support. As I said, our core values really are science and evidence-based, and so we are going to continue to move forward. And we were going to put ourselves out there, for lack of a better term. There's very likely a target on our back, but we have to stand for what we believe in. And so we are moving forward and taking risks. This led us to engage in a variety of lawsuits. And as I said, we've been involved in lawsuits. I've been at APHA for 21 years, and we've been involved in lawsuits, or one suit in some way, shape, or form, probably almost every year. We are currently involved in 7 active lawsuits. And that is highly unusual. So I'm just going to go through these all really briefly and give you an overview of what they are. The first lawsuit that we filed was the APHA v. Doge, and that happened on Inauguration Day at 12:01 p.m., right after the inauguration happened. That was making sure that if Doge was going to act, it should act as a federal advisory committee. It needed to abide by the laws of the Federal Advisory Committee, which include transparency. This lawsuit was something that we weren't the only ones to file, but it was one of those issues that has resolved itself over the course of time. A few days later, we filed a lawsuit with a variety of other partners against OMB when they tried to freeze all grants while they were looking at whether or not all grants coming from the federal government through OMB had or abided by the priorities of this administration. The next major lawsuit that we are involved in, that is an ongoing lawsuit, is AAP versus RFK, and we are one of the lead plaintiffs here. And it's really important to think about this as not just an issue for medical providers, but also for the public's health. And that is why we thought this one was so important. This was when RFK made the decision to remove all of the sitting members of the Advisory Committee on Immunization Practice, and then went on to change the schedule. We have been very well received at the lower courts, in which they have said that they cannot completely replace the ACIP members if they do not abide by the laws to replace them. And there were serious issues with the people who were replaced, as well as the change to the childhood vaccine schedule is also on hold because again, it was not transparent, it was not evidence-based, it was a decision made in basically the dark of night. Several other lawsuits that are ongoing is the APHA versus NIH that we filed relatively quickly after the executive order that suggested that there were parties that disfavored parties, and they should not be, research for them should not be funded. And then it was what you would expect. It was grants related to DEI, grants related to vaccines, grants related to some international partnerships. And this is a suit that is also ongoing, although we have had the original group of grantees have received or should be able to be receiving their grants as it stands. There are a whole array of other reasons that grants have not gone forward. They have not actually gotten to the approval stage. And so there are ongoing conversations, but the Supreme Court said that for many of those kinds of distinctions, they would have to go through a separate court that looked at the Administrative Procedures Act. And so that was required each grantee to go through that case or through that court by themselves. And so that obviously has not been resolved satisfactorily. The FG-AFL-CIO v. Trump is about the reorganization of the federal government and the layoffs. That is a case that has been, we have seen some positive rulings, but also has been the administration or the court allowed the administration to continue to do the reorganization even while the court was considering this case. So that is an ongoing issue as well. Since these were the ones that I just mentioned were the ones that we've been working on for a bit of time. The more recent cases that we've been involved in have been related to EPA, but these are just some of the public pronouncements related to the vaccine case, and really lets us talk about the importance of making sure that science, evidence, and transparency are part of any decision making by this government. So we've moved on. As I said, the newer lawsuits are related to EPA. These are relatively new. They're still very early in consideration by the court, so there hasn't been any major consideration or public conversation or decisions by the judges yet, but these are moving forward in discovery. So those are not the only lawsuits that we are involved in, but those are the big ones where we are involved as a plaintiff. We have been engaged for in a variety of different ways, including signing on to Amicus briefs on a variety of EPA rules. One of the things that is most important, and referring to the slide that Sabrina had earlier, one of the ways we make a decision whether or not to get involved in a case is, are we defending challenge policies that we know the policy is based on current science and evidence, or are we trying to enforce existing laws? And if you look at this whole array of different cases, there is a very clear issue that we have with trying to challenge the policies that are undermining the public's health or enforcing existing laws that we know are in support of the public's health. And in the last year and a half, we have been involved in these issues as well. Historically, APHA only gets involved in cases once they reach the federal court. There's a rare exception if we do not have a state affiliate, and that's what's happening in West Virginia, or if our state affiliate is unable for a variety of reasons to challenge something in the state court, but they want APHA or the public's health voice to be included, and that's when we'll get involved. We have had a whole array of decisions on some of these cases, and we are still trying to figure out ways to assure that people have access to all of the services and care that they need. As I went through this, you can see that these are all in various stages of the legal process. Our goal is to proceed in pro-health direction. We have very limited staff and bandwidth to do this, and so we need to be very discerning when we make the decision to be involved in a case or not. Unfortunately, we've had to turn down some cases that would make sense for APHA to engage in, but we haven't had the bandwidth to do all that. We've been very lucky to have the support of some of those pro bono lawyers that Sabrina talked about to help us in support of these cases. And so with that, I turn it back to you. Thank you.
Thank you so much. I want to really thank Sabrina for her introduction and level setting, and Susan for explaining the really important work that APHA is doing. As Sabrina said, I'm Wendy Parmet. I am a professor of law at Northeastern University School of Law, where I'm co-director of the Center for Health Policy and Law. And I like to use the word house, the George Consortium, which is a network of public health law academics, and a project called the Public Health Law Watch, which is sort of the activist arm of the consortium. And I'm going to talk to you today about our work around amicus briefs. And I should note that our work is funded by the Robert Wood Johnson Foundation. So what are we doing with this amicus project? Several different things, but to get going, we are tracking litigation. We are tracking cases that are significant, that have some potential for significance for public health or health equity. And importantly, when I say we're tracking cases, we're not only looking at decisions the courts have rendered, but we're trying to track the filings, including at the state level. We're trying to understand what's bubbling up, and that's not always so easy to do. We'll get back to that. We are prioritizing state and local litigation precisely because it gets less attention. And lots of folks talk about, and lots of different priorities. Big organizations often are able to intervene in federal litigation. There's really often a dearth of intervention on behalf of public health in state litigation. We are working by coordinating and facilitating amicus briefs, amicus or friend of the court briefs. And we do that in a whole different spectrum of different ways, which I'll talk more about. And we are partnering with experts, organizations, particularly ChangeLab, experts such as Defend Public Health, which Greg represents and he'll be talking about, and other outside counsel. So, as I said, one of the things we do, and one of the things I really want to focus on, are amicus briefs. These are also sometimes known as friend of the court briefs. They go back a long, long way in our legal system and in legal history. And in the United States, at least at the Supreme Court level, they go back to 1823, where the Supreme Court sought input from the Speaker of the House on the consequences or potential consequences of a decision. Amicus briefs come in lots of different flavors, okay? One thing they can do, and what we're trying to specialize in, is introduce scientific or technical data that, for a variety of reasons, is not in the trial record. So they can provide additional scientific evidence and or help put the scientific evidence into a clearer context for the court. In doing so, we're writing what are often called Brandeis briefs. Louis Brandeis, former Supreme Court Justice before he was on the court, supposedly pioneered these briefs in a 1907 case. This was not a amicus brief, but he really tried to give the court medical and sociological evidence, and that's what we're doing. So why these amicus briefs? As I've already said, we can bring scientific expertise to the courts in ways that the parties cannot. Parties have to focus often on the legal issues. And sometimes, particularly in appellate briefs, for example, there's just not enough space in their brief to deal with all the legal issues and also provide perhaps all of the scientific evidence that might help the court understand what's going on. So in one sense, we can supplement what the parties can do. Research has shown that courts place special value on amicus briefs which discuss medical and scientific issues. So, and I'm overstating it a bit, but having yet another party analyze what a Supreme Court decision means might not be so useful to the court. But bringing in expert evidence that is not otherwise before the court, courts often appreciate that. Amicus briefs provide an opportunity for diverse coalitions of lawyers, community groups, organizations, and experts to come together and to help influence litigation where they may not be a party. As Susan said, APHA, for example, is involved as a party in many cases, but they also can be involved and are involved in other cases through amicus briefs. As I've already mentioned, this seems to me to be particularly important at the state level. There are far fewer amicus briefs at the state level. And so it's a way of bringing the voice of public health and affected communities to state courts. And again, critical to this process is partnership and coordination. If we're going to bring the voice of experts and the evidence to the courts, we want to work with the experts. And Greg will talk more about how we do that. So as I said, amicus briefs have a long and ancient history, but we have seen a dramatic increase in them in the last 80 years, 800% increase at the Supreme Court alone. in the Supreme Court's 2019 to 2020 term, which is the last term for which we have the data. 940 amicus briefs were submitted, and I would not be surprised if that number is far higher now. We've also seen courts rely on, or at least cite and reference amicus briefs far more often. Another trend that has happened is that once upon a time, even 10 years ago, amicus briefs were almost always exclusively filed at appellate level. So the courts of appeals, state Supreme Courts, U.S. Supreme Court. Now we are seeing, and we ourselves have been involved in amicus briefs at the trial court level. And this is really important because you want to get in and influence the litigation at the get-go. Sometimes it's too late by the time you get to an appeal. And I just want to add that the Supreme Court's decision a few years back in Loper Bright, which, and I'm oversimplifying, basically said that administrative agencies should not get deference from the courts in cases of statutory ambiguity. These have made it more important for the courts to understand the scientific evidence because they are no longer deferring to the agencies. So an example of what we have done and where it worked, Susan talked about the fact that the American Public Health Association is a party in the case AAP versus Kennedy, which is challenging Secretary Kennedy's a variety of different actions that he has undertaken since about a year ago, a little over a year ago, with respect to ACIP and the childhood vaccine schedule and COVID recommendations. We were Defend Public Health, an organization that Greg represents and he'll be talking to you about, reached out to us and our colleagues at the George Consortium and said, can we get involved in this? And we did. We agreed to work with them. We found outside counsel, and I'll talk a bit more about that in a minute. We worked with an amazing team, volunteer team of epidemiologists associated with Defend Public Health. And then we, the lawyers, turned the scientific information that they gave us, the research body that they gave us, into the legal language and turned it into a brief. We have filed 2 briefs in this case before the district court. And I am thrilled to say, as Susan said, the district court issued a stay of most of Kennedy's actions and actually have cited the amicus briefs in 2 different opinions by the court. The litigation continues, and we're working on the brief for the appellate court later this afternoon. So, but what I really want to stress, what worked and was, to me, was the most important part of this, is the partnership between the lawyers and the scientists. There are challenges, right? And one I really want to stress is identifying cases early enough. That's not so hard to know where you might want to get involved, assuming you have the bandwidth and the resources for the major federal cases like AAP versus Kennedy. But there are a lot of really important cases that may have very significant public health implications percolating under the radar in state courts. And it's often hard to find those cases until they get up to the appellate level, at which point there's often very little time to put together the team of pro bono scientists and pro bono lawyers to put together the brief. So that's a challenge. We are working on it, and later I'm going to give you a QR code. If you know of cases that we should be following, let us know. None of the legal tracking databases cover all state and local cases. It's really hard to find state filings before the decisions are rendered. Finding pro bono counsel, we need counsel. We are not admitted in every state, and we don't have the capacity to file the brief, so we need to work with pro bono counsel. That's not always easy. Law firms are busy. Law firms are have a lot on their plate. And to be frank, and it's been somewhat disturbing, in this political climate, we've had law firms and lawyers say, we really wish we could help you, but we're wary of getting involved in some of these cases. Politicization of the courts is a somewhat different issue. Just looking over today's news and all of these decisions that were decided by the Supreme Court, 6-3, 6-3, 6-3. I think we can't deny that there has been politicization of the courts, that there are many, certainly justices on the Supreme Court and judges throughout the legal system that are pretty political, ideological, and frankly, unfortunately, at times partisan. And we need to recognize that we can give some judges all the scientific evidence in the world and it can point in very clear directions. But some judges you're not going to convince, even if you have the law and the science on your time and on your side. And then there's the timing constraints of litigation. It's challenging for those of us who are doing this pro bono, who have sort of day jobs, so to speak, to find lawyers to do it. Litigation is very time consuming and often operates on a very fast schedule, and that can be challenging. Some other issues, what we can do when we file an amicus brief is give the court the science and the context. But we can't shape the legal claims, the issues. We can't compensate for a poorly drafted complaint that didn't raise an issue that should have been raised, right? We don't control the litigation in the way that the parties do. Public health would need to be a party in the litigation for that, as Susan was just saying, APHA has increasingly been. But there are other cases where we can intervene, but no matter how much science we give, if there's if the case was filed, to give an easy example, after the statute of limitations, there's nothing we can do. The doctrinal climate right now is challenging, especially in federal court and in some state courts. We have a Supreme Court, that is, let us just say, much less interested in the scientific evidence, much less deferential to scientific evidence than it used to be. And the last thing I want to say is it's great. It feels marvelous to note when a court cites you. It makes my day when you have an amicus brief. But we do need to recognize that citations don't prove influence, right? The court might have come out the same way anyway, and just cites you, right? It's almost impossible to measure how much lawyering or amicus briefs or anyone's brief actually affects the outcome. I believe strongly that it can with certain judges, but as I said, I think some judges are dug in and very political. And so, they may cite you or not cite you, but probably they would have come to the same decision anyway. So how can public health support litigation beyond beyond working with us in the way that I said we worked with Defend Public Health? One is working as expert witnesses in litigation, helping to get some of that science, not just in through briefs, but actually as evidence in cases. Second, even when we're not doing amicus briefs, partnering with the litigators, meeting with litigators, helping litigators whose expertise is not in the science understand, get a deeper and better understanding, and frankly, making sure that we, the lawyers, get it right. Because we don't have the training that the scientists, that the public health experts have. Public health practitioners and researchers can also frequently, depending upon your job, and we might talk about this later, but also sign on to amicus briefs as individuals or as groups. So in other words, even if you're not participating in the drafting and you're not part of the team putting it together, signing on can make a difference. As I mentioned earlier, studies show courts listen to briefs submitted on behalf of scientists and physicians and healthcare providers. So moving forward, in addition to continuing working on briefs and looking for cases to work on, we will be convening a meeting in the fall at Northeastern in Boston on our campus to try to get experts, scientists, and others together with the lawyers in the room. We want to forge deeper relationships between scientists and lawyers, and we want to build greater understanding so that if we, the lawyers, have a scientific question, I want to know who to call. And I want the scientists to know if they see a case and they're worried about something that's going on, maybe we shouldn't get involved. They know who to call. So we really want to build teams and build coordination, and also involve as much as possible communities that are affected in these discussions. So that's going forward. And so I'm going to leave you with my call to action. You can reach us through this QR code, which has a brief survey, because we want you to tell us about state or local cases impacting public health or health equity that you think we should keep our eye on, either to inform the public health community. And I should have mentioned, we also do a biweekly newsletter on litigation that we should just inform the community, or maybe we should be gearing up to get involved in. Help us build a network of scientific experts. We are also looking for lawyers who might be willing to help us on a pro bono basis around the country. We have a nice network in certain states, but we don't necessarily have lawyers in every state. We definitely don't have lawyers in every state. And, let us know how we can support your work and help us by sharing contacts and ideas. And with that, I think, turning this over to Greg. Yes.
Hey, everyone. I'm Greg Gonzalez. I'm with the Yale School of Public Health. Probably more relevant at this moment is that I'm a member of the Coordinating Committee of Defend Public Health, a group of over 10,000 public health experts, clinicians, lawyers, students, advocates that was formed right after the election to push back against what we're seeing happen all around us. So I want to talk about some of the challenges for scientists, in particular, in working with lawyers and other legal professionals on amici, but also other kinds of legal documents like affidavits, et cetera. And I think the fundamental thing is that we're strange bedfellows, right? We speak different languages. We're trained differently. Lawyers are driven by the law. I'm a public health person. I'm really driven by population health outcomes. But my colleagues across the street at the medical school are really dealing with individual patient level care, right? And we use different kinds of tools to make arguments and decide them. Lawyers may rely on rules and precedent and authority. Epidemiologists like myself will deal with statistical inference and causal reasoning, and then physicians maybe use sort of abductive reasoning, the educated guess based on limited evidence in terms of clinical evaluation and judgment. So another piece of the puzzle in terms of the challenges that arise in these kind of collaborations is that we have different relationships to uncertainty, right? Lawyers are making a case, and uncertainty in some ways is a burden. Somebody has to be right. The court's going to make a decision. Epidemiologists, on the other hand, we couch everything in uncertainty. We bound our statements, we bound our conclusions in papers and in other kinds of public documents. And clinicians sort of straddle the line here. They need to make a decision for a patient in the given moment, but it's changeable and revisable based on new information. So we're dealing with different cultures, different ways of making decisions, how we think of uncertainty. But are there ways to get over these hurdles? Yes. And, in the current moment, working with Wendy and Dorit and Shannon on Amicus brief for AAP versus Kennedy, there's some principles that sort of emerged in our relationship over the past few months. One of the big things for me is trust is fundamental. Often lawyers, and not Wendy, Dorit, or Shannon, will say, like, couldn't you say this or couldn't you say that? And it's very, very hard for epidemiologists and clinicians to go out in front of the data. There might be strength in making a scientific argument that is more definitive, but the great thing about our partnerships with Wendy and Dorit and Shannon right now is that they understand our limits. They understand how constrained we are by the data that we see in the literature or in studies we've crafted ourselves. You can find expert witnesses to say anything. One of the reasons, it's great to work with Wendy, Dorit, and Shannon is that we share values and we share a commitment to the case. We're not just there because we're guns for hire and can provide some scientific evidence in an amicus brief. I think we all sort of feel strongly about the outcome of AAP versus Kennedy. So how else can we work together? It's been really important to help the epidemiologists and scientists working on these amici and trying to think about how you frame the need for evidence and scientific support. Like, what do you really need for this Brandeis brief, for instance? What kind of evidence do you need and what kind of form do you need it? We, are not experts in all the details of a given situation, but we know how to sort of find that out within my broad area of infectious disease epidemiology. And it really helps to shape our research process when we have a clear framing of the evidence needed. One thing I've learned through the AAP versus Kennedy process is that this is all a moving target, right? The arguments are evolving on the other side, and we have to change as the arguments change from the one party. We have to change the arguments on our side as the case makes its way through the courts. We're not changing our fundamental theories about the scientific evidence, but what is needed in any given moment may change. So the research needs today may not be the same ones that you're going to use tomorrow, and they may not even need you tomorrow. I mean, there's certain times where we're like, are we going to do this brief in the next round of the case? Maybe yes, maybe no. And so, in addition to trust, we need to sort of be patient with each other. Our limitations are different kinds of disciplinary training and ways of seeing the world. And I think that's the sweet spot for me in terms of successful partnerships. So, we have lots of data that we can offer up to our partners on the legal side in terms of crafting an amicus brief. But we need to have it bounded for ourselves, right? How much complexity do you need? Too much could be neither useful or required. So trying to sort of bound our research, but also sort of our analytical approach really depends on how much is enough for the products that we need to prepare for the court. So how do you want to edit it down? How do you want us to revise our bullet points for a given part of the amicus brief or some different paragraphs, so that without undermining its essentials? Because scientific arguments are quite substantial, and the context of vaccines are complex and intricate. How do you get it down to sort of the essentials that are good enough or more than good enough for an amicus brief? So, why do we do this? Many of us in public health see our discipline as consequentialist. We're not here to make knowledge for knowledge's sake. We're not abstract practitioners. So we really want to be doing good in the world. And that's why we sort of reached out to Wendy and her team in this context. And many of us during COVID were pulled into legal cases, not just through amici, but through affidavits or witnesses in cases. I did a lot of stuff on prisons and decarceration. But what's really important is many of us have little exposure to the world of health-related litigation. And so we need to establish relationships with lawyers. And could there be a more structured way to create opportunities for us to help? And Wendy just said she's bringing together lawyers and scientists at Northeastern in the fall. Absolutely needed. We need to be together talking way in advance of cases arising in any given moment. So, I teach a clinic between the law school and the public health school here at Yale. And I think we need to think about how do we get to people earlier in their public health and legal careers. And that's why public health law classes shouldn't just be in law schools. They also need to be in public health schools and other health professional curricula. We have a public health law class at the Yale School of Public Health. We could do more to build interdisciplinary and multidisciplinary bridges across campus. And as I said, we have a clinic that enrolls law, public health, and other kinds of health professional students, and this is critical. And I think we need to be able to bridge the divide early in people's careers. And finally, I think we're up to questions now.
Yeah, thank you. Thanks so much to Susan, Wendy and Greg for sharing all of this information. I know there's some questions that are in the chat, so we'll get to those. And then folks also submitted some questions in advance. And I just want to lift up one clear theme from that question, which is around how folks can get involved in this work. And I know we've touched on that in various ways through all the different presentations, but I want to just ask it explicitly now to sort of bring it together a little bit. So how can folks from different sectors, backgrounds, and institutions get involved? I think litigation can feel like such an unknown. And so I just want to reiterate the piece. Some of the questions we got were sort of like, I don't think I'm allowed to get involved in this given my employer. And we're not going to provide legal advice about sort of what your employer and the laws in your state say you can and can't do in terms of this, but just at a higher level, what are different potential roles, maybe put it that way, for government employees, academics, CBOs, and others. And maybe Wendy, I'll start with you, but I'm happy to hear from everyone on this one.
Well, thank you, Sabrina. I also want to add, in terms of what people can do, it depends obviously on where they're located, what their expertise is, but also what their employment is. A lot of what we're talking about in terms of, really being very active is easier, obviously, for people who are working in the private sector right now. So I just want to acknowledge that. But there are lots of different ways people can get involved, right? So people, as I said, join Defend Public Health, right? Join APHA and support organizations that are getting involved in litigation in different ways. And I think that's, in some sense, the first step. Let us know, let these organizations know about cases that are, or situations that you think should be cases, right? Troubling things that are happening where you want to talk to a lawyer, and reach out to ChangeLab, reach out to the Network for Public Health Law, right? Reach out to other legal organizations that get involved. And then, as I said, let's start forming partnerships. And get involved. We want to hear from you. That's why we had the QR code. We want to be informed. The other thing I think what I want to say about the partnership is, and I really appreciate that Greg talked about, the different disciplinary approaches and the way different disciplines see the world. It's so important to keep in mind. But this is particularly for the researchers and epidemiologists and others on the call. I'm not asking you to do cherry picking or, biased research, but when you see that there are legal issues and of research that could be done, right? Let's get the bodies of evidence to, build the case. So sometimes it's helping us lawyers see or understand the evidence, but sometimes there may be evidentiary gaps and it may be something where we need more studies to make the case stronger. So that's another way that people can get involved. But there's really an enormous spectrum, and maybe someday we should do a whole webinar on how people can get involved.
I'd like to jump in here too, because there's a variety of additional ways. When we were first working on the APHA versus NIH case, I did a number of outreach I did outreach to our members a number of times, asking for their stories, for their information. And that actually became the course, one of the primary ways that the courts understood the implications of this case. And also, those were the grantees who were able to be reimbursed. So if you get those kinds of requests from an organization that you're involved in, it was originally done anonymously. We sent it to the lawyers. They reached out to the grantees and were able to fill out the information. But that was critical to making that case and offering the opportunity for some people to be reimbursed. Some of you probably know about the recent OMB regulation that is focusing on the making sure that there's a political person involved in the determination of who will get a grant and who will not get a grant. And that's obviously simplifying it, but right now we and a number of other organizations are asking for comments. What are the implications of this for the work that you do to go to OMB. And this is going to help build the case when in all likelihood that case will be filed when the regulation is finalized. And so this is going to be it's a core piece of information that the lawyers can use. And finally, I have a shameless plug, but we have a fundraiser up right now. As I said, we have been very lucky that most of the cases supporting us, or most of the lawyers supporting us, have been pro bono. There's one case, and that's the AAP case, AAP versus RFK case, that is not a pro bono law firm. And so we're trying to help them raise money so that they can continue to do that great work and continue to move this case forward. And I was trying to figure out a way to get that link out to the group at large. But I'm happy if anybody's interested in sharing that. We would really appreciate that. The money is really to support this case and help the lawyers continue to do this work.
Thanks, Susan. I think there's a question about how you can get involved that I think, Greg, you're probably best, or like how and whether I should say to get involved, that I think, Greg, you're probably best suited to address around, they know that you can find an expert to put your name, experts are available for hire for anything. So as scientists, I think there's maybe a fear of getting involved sometimes and how that might affect your career. And so the question is about the nuances and sort of decision-making process. How do you know whether and how to get involved?
So there are bad actors in every field, right? During COVID, faculty member here was high on hydroxychloroquine and saying how it was a cure for COVID. It talked about shared values and commitments. If you understand the case and the stakes involved, I think you can make a clear, compelling reason to reach out to people who are working on the case, or who might be willing to work on an amicus with you to get involved. In terms of hurting your career, I'm going to try to be delicate, but we're in an all hands on deck moment. Susan listed close to a dozen cases that APHA is involved with. We're scratching the surface of what's happening in this country right now on the attacks on public health, biomedicine, and research. What's going to hurt your career is if the administration wins its battles in the courts, wins its battles in the court of public opinion, and wins its battles in the halls of Congress. And so I feel compelled to say, you can't sit on the bench anymore, right? There's going to be no career to go back to if the OMB rule passes, if the continuous onslaught at NIH continues. So I would say find people you trust, work with them, and get to work.
Thank you. I know we're coming up on time. There's a couple more questions, and I think we can probably follow up offline with some folks too. There's some specific questions about involvement, but there's one question here around how to identify if briefs are being done in your area or your area of focus that I think Wendy I don't know if you have an answer to that, but just how can people keep tabs on this and know when to get involved?
I'm not sure I know exactly what the question is, whether people just want to know. I mean, organizations, many of the pro bono organizations that are involved in these cases do list it on the website. But one way to do it is if you hear about a case, if you know about a case, if it's in the press, or you know about a case, Google in the press, call the lawyers, contact the lawyers on the side that you feel aligned with, and say, are there amicus briefs? Are there organizations that are supporting you? Are there ways we can help? And I think most of the time you're going to get a receptive answer if there is, right? I mean, if you were to call the lawyers who were doing AAP and said, I'm scientists and I want to help a amicus project, they would send you to me, right? They know what we're doing. And that's often the easiest way, because the press usually does mention the law firms that are involved in the case. And that may be the easiest way without having to do a legal tracking kind of thing.
Yeah.
We also sign up, by the way, on our survey. You can sign up for our our survey. We do a bi-weekly newsletter about cases that are coming down the pike, about filings. We talk not only about judicial decisions, but about complaints and motions that are pending. And that's another way to find out what may be of interest to you. And then you can ask us who are the lawyers, and we'd be happy to help you with that.
Thank you. So I think we'll end on that very practical note. We do have our contact info. I think if we can bring up that last slide. Thank you. Thanks so much to everyone for joining us today. This has been a really interesting and helpful discussion. I think for folks, I know we're getting a lot of feedback. So thanks to all of you for attending and listening. And please do reach out. There's more to come on these topics, and we will keep folks posted. So thanks to everyone. Enjoy the rest of your day.